And I'd like to welcome you all to today's program on Bills 20 and 26. A program I hope you will find is indeed filled with common sense. I'd like to begin taking a moment to thank all our faculty, not all of whom are as yet visibly present, but all of whom certainly have given very generously of their time and talents in preparing the binder of materials you have and in making the presentations that you'll hear today. We're completely dependent on the efforts of our volunteer faculty, and we're certainly grateful to every one of them. You will have a binder of materials. Two of the papers will be loose. One of them is Julia Ryan's paper. The other will have been handed to you with the binder, Joanne Davies' paper, and those came back a little late from the printer, so we'll ask you to drop them into the binders. I'll also point out very briefly, since we're a few minutes behind, that as usual faculty biographies are included at the head of the binder, and I want to draw your attention to this course evaluation form. These are, to a substantial degree, what guide us in planning programs that will best meet your practice needs, and so you would be acting in your own self-interest as well as doing us a very great favor if you could complete it throughout the course of the day and leave it at the registration desk when you leave. If that's not possible for any reason, then please do fax or mail it in. We do read them. We take each one very seriously. I'll begin with the briefest of introductions of our three chairs. Already well known, I'm sure, to many of you. Virginia MacLean is a partner with Castles, Brock & Blackwell, where she practices in the administrative law field with emphasis on municipal law. And in addition, she's a member of the executive of the CBAO's municipal law section and council. To her left, Jim Harbell is a partner of Stikeman Elliott, head of the Municipal and Environmental Practice Groups, and a member of the Real Estate Department and the Independent Power Practice Group. Our third chair, Bob Boxma, is seated in the front row here at the moment, as a partner at Smith Lyons, and his practice is concentrated in municipal and land use planning law. He's also been a bar ads instructor in public law and past chair of the Municipal Section CBAO Executive. Please join me in welcoming our chairs. Thank you.
Without further ado, I will commence the brief introduction to Bill 20. As you can see by the agenda, we have a very limited time schedule, and we've also reserved all questions on the matter to the very end, so we hope you'll all stay for the question period if you have those questions, or alternatively reduce them to writing and we will address them. Unfortunately, if you're not here, you won't have the answers, so we would urge you to stay for the question period. I am going to commence with a very brief overview of Bill 20. Joanne Davies will be filling it in much more detail than I will. So I doubt that you will have any questions out about what I say. What I like to do is just set the stage for Bill 20. The Bill 20, which is now the Land Use Planning and Protection Act 1996, received first reading in November 16, 1995. Within 6 months after coming into power, the current government introduced legislation to amend the Planning Act. Initially, that legislation was taunted as being a bill to repeal Bill 163, and was touted in that mindset. Joanne, who works for the government, probably won't comment on this, but it was indicated that it would be a substantial rewrite of the Planning Act, which had just been proclaimed by Bill 163. We had hoped, I think, some of us, that we would be going back to the 1983 Planning Act. However, it was not to be. Common sense has brought us to further amendments to the Planning Act as amended by Bill 163. And it also brought some changes to the Assessment Act, the Development Charges Act, and the Municipal Act. There's minor changes to the Ontario Heritage Act. Those are all contained in the one bill. The subsequent speakers, as I said, will address the detailing of the changes and whether or not those changes are substantive and what their opinions are on those changes. In the time allotted to me, I propose briefly to give you the highlights, the bare bones of the changes. You'll find in your materials a chart as an Appendix 1, which is a summary chart. And you will also find in your materials, and I would commend you to look at the regulations that go with the Act, and those are Ontario Regulation 196 of 96 to 200 of 96. Those are also came in effective on the May 22nd date. Now, the summary chart shows you the existing Bill 163 and Bill 20. Unfortunately, it is difficult to get a real understanding of the legislation because there is no consolidated act around at the moment. I understand that UDI did one internally. I also understand that Canada Law Book will shortly have a consolidated version. My version is the 163 version with pieces of paper stuck into it, being the cut and paste method. But it does enable you to see how the changes work out. In the summary chart, then I have in one column listed the section of Bill 163 Planning Act, and then I've listed the Bill 20 Planning Act sections. So briefly, there have been some changes to definition of public body, and official plan has no longer got a definition. The policy statements, the big change there was that shall have regard to has been returned, and shall be consistent with has gone the way of the dodo bird, we hope. The criteria, therefore, is back to what it was prior to Bill 163. Most of the changes on the official plan relate to, I've listed them, and they'll start on page 3 of the materials. The minister's powers of exemption of an official plan from approval by an approval authority cannot be delegated to council or further delegated. They've removed that power, but the minister can delegate to a planning board if it has an official plan. There's been a slight change. As you know, there's currently a provision of what shall be contained in your official plan. And there's been a slight amendment to that to avoid confusion as to what the section means. So the words shall contain the prescribed criteria have been deleted from that definition section. The 2 residential units in a detached dwelling provision have been removed in total from the legislation, effective November 18, 1995. And so the official plan provisions have been removed, as have other provisions throughout the legislation. Now, there are substantive changes to the approval process that will be dealt with by Joanne, but I've highlighted on page 4 some of those changes. The time periods have changed. Exempted plans can be appealed 20 days after completion of written notice of adoption of the plan. And there's a time period given for giving that notice, and that's 15 days after its adoption. Must be given within that time period, so that there is a tightening up of the appeal time periods for exempted plans. If it's not exempted, it's 90 days after the plan is received by the approval authority and they fail to give notice of decision. You may then appeal. In terms of the other time periods, they speak for themselves, and you will note if you read through that chart what the time changes are. In the zoning field, one of the changes related to the provisions on 34.10.1 and 34.10.3. Now, the changes that were made are not all that substantive in terms of that a word has been removed, but I think the effect would make things a little more palatable. The specific changes that have been stricken are the removal of the words all. And you wouldn't have thought that moving the words all would that make that much of a difference, but sorry, I'm just here looking for the specific section. by taking out those words, it makes it a little easier to work with the section. But the scope still remains, so although the words have been removed, just be aware of that 20 sub 1, 2, and 3, which are the changes to the new paragraphs 3.1, 3.2, and 3.3 that were made by the 1963, Bill 163 still remain. The prescribed information provisions that were put into the Bill 163 Planning Act also remain. What Bill 20 has done is try to clarify it through amendment. And you will find in section 25 of Bill 20 the changes that are made to prescribed information as it relates to zoning bylaws. Similar changes apply to official plans and to all other areas. The time period for the appeals on zoning bylaws are tightened because the clerk, again, is put under a time restraint by the amendment. The clerk must, within 15 days after the last date for filing a notice of appeal, send that record to the Ontario Municipal Board. So there is a tightening up and an ability to get matters heard faster through the shortening of time periods. The right of the Ontario Municipal Board to dismiss an appeal without a hearing has been clarified. There was a great deal of concern expressed, I think, in Bill 163 when that section went in, and there has been additional words made to protect the rights of the individual so that the board has some criteria before they dismiss. The words, where an appellant failed to make oral submissions or written submissions to the council and provides no reasonable explanation for the failure, give the board some criteria on which to determine whether or not to dismiss on those grounds. In section 41, the site plan section, they did add the provision that it's a proper condition of site plan approval to require a conveyance of land for public transit right-of-way. I know on that issue that the Canadian Bar had expressed its concern about that section being there, but the committee, when they heard the matter, determined that that was a proper condition of site plan approval. So I guess you're going to see more busways like there were in Mississauga that are now sitting vacant, pieces of land being required. And I guess what hasn't been addressed is what happens once you get them and you don't require the busway. What does the municipality do with them? I guess they have to dispose of them as they would other lands in accordance with the Municipal Act. In terms of the consent provisions, again, the such other information as the approval authority may require provision has been clarified. It still exists in the consent section. I've noted on page 5 the removal requirement for public meeting to be held. But the section does say unless required by regulation. And as far as I'm aware, and Joanne can clarify it, there's be no regulation filed yet to say when the public meeting would be required, and maybe Joanne will comment on that. By the way, the regulation that's relevant to the consents is 196 of 96. The appeal provisions on subdivisions arise within 90 days after the date the application is received by the approval authority. Under the old act, it was 180. The changes to the time period to the board, 20 days after the date of giving of the notice of decision, formally 30. So again, a tightening of time periods. The materials, in your materials, there's an error, a typo. The reference on page 6 is not subsection 29.1, 30.1, it's 29.1 of Bill 20. And again, the requirement for a public meeting in the case of consents is, again, can be prescribed by regulation. There is no regulation, again, passed, so absent the regulation, no public meeting. The transition periods are confusing. insofar as you have to read them all together, and there are a number of transition periods. Important thing about official plans, however, is that if one was passed before any proceedings commenced on or after March the 28th, 1995, but can continue under Bill 20. And there's a number of examples of what is constituted as a matter or proceeding commencing on or after March 28th, 1995. So there's an opportunity for people to bring, and I would suggest they probably will, bring all of their applications in under Bill 20 and thereby avoid all the problems that one would face with dealing with two sets of legislation and one being more restrictive. Like one would tend to want to bring everything back under the new bill. That, in a nutshell, is a summary of the changes to the Planning Act. The Development Charges Act provisions will be dealt with in a little more detail by subsequent speakers. The Assessment Act provisions are fairly housekeeping, in a fairly housekeeping nature. The Municipal Act provisions are consistent with the changes with the 2-unit houses that were made to the Planning Act. And again, the Ontario Heritage Act changes are somewhat housekeeping in nature. So in a nutshell, that's what the bare bones of the provisions are. I'm afraid it's not a very exciting topic, but I think when you hear the comments that are made and you look at it in more detail, it is beset with a number of problems which I think make for a very interesting stepping through the planning process these days, and I think it's important that we all get the consolidated version so we can fully appreciate what those changes are in one document as opposed to flipping back and forth. So that's briefly what I have to say on Bill 20. And I will now pass over to Jim, who is going to deal with Bill 26, which you're going to stand up, right, Jim?
I'm going to stand up.
Okay, thanks.
Good morning. First of all, I'd like to commend all of you for being out here. It's great to see so many friendly faces in the crowd. One of the things when people ask me what do I like about my practice, one of the answers that I give them is that the members of the municipal bar, I think, are a great crowd. We tend to be a pretty closely knit, friendly, cooperative group, and it's really a pleasure to see that so many of you from so many stages of both junior to senior have all made it out this morning to join us, so that's great. I've been given the difficult task of trying to summarize for you this. Bill 26, and in particular, we've decided we're only going to do the municipal requirements, which is maybe only a third or a quarter of that. Now, it's really difficult, I've thought about it, trying to make light and amusing something that is amendments to 47 different acts and produces 3 new ones. So I've given up trying to do that, but let me see if I can at least be focused, and let's move through some of these provisions and hopefully help you a little bit into the middle of the legislation. As a general approach, I think what the legislation is doing vis-a-vis municipalities is it is definitely streamlining. Without doubt, it is quite clear that was the overriding desire of the government, and I believe as you look through the provisions that the government has accomplished a great deal of that desire. But I call it streamlining with an edge. I think there has been much discretion that has been left to regulation. Many of those regulations are not out yet. There are apparent broad powers with respect to user fees that have been given to municipalities, but there are also many opportunities for the provincial government of the day to take back those powers if they don't think that the municipalities are properly exercising them. So it's very clear that while it's been streamlined, there's definitely an edge there so that you never move very far from the strong philosophy and matter of law that municipalities are creatures of statute, they are creatures of the provincial government, and it's quite clear clear when you look at the underlying regulation power in Bill 26 as it relates to municipalities that the province is retaining that strong control over municipalities. So I liken it a little bit to a bungee cord. Municipalities have been given the opportunity to kind of head out and free fly, but there's a snap back potentially. And on the snap back, depending on how municipalities have been behaving, maybe the bungee cord turns into a noose. It's really going to be a question of having an analytical review of all of this about 5 years from now. And it's going to be up to municipalities as to what degree of freedom they choose, how the electors respond to the municipalities depending on that freedom, and again, how the provincial government of the day does. So I want to pick 4 areas to deal with. First of all, freedom of information. Second, then we'll move into restructuring, which got a lot of publicity when Bill 26 went through. Thirdly, licensing. And fourth, just briefly on conservation authorities. So firstly, freedom of information. Number one up change for municipal freedom of information is user fees. You'll hear me say that frequently. It's here under the freedom of information. Second, gain to deal with the streamlining and ability by the head to throw out a request if the head, the person responsible for municipal freedom of information, believes that it's frivolous and vexatious. And thirdly, there can be a dismissal of any request for information where the decision maker doesn't reasonably believe that that information exists. So they can simply dismiss it, no mediation, no investigation. It can simply be thrown out up front. So back to user fees for the moment. Again, prescribed by regulation. I'll probably say that 20 times in the next 15 minutes. The user fees can be for manual costs, so an hourly rate to search the files, costs to prepare the record, computer and photocopying costs, shipping costs, and other response costs. All of those will be established by regulation. There is also the ability of the municipality to waive these costs where the municipality believes it's fair and equitable. And that is not defined, and the regulations are not going to deal with it. So it's up to municipalities to decide, for example, if it's a charitable organization, does a municipality want to promote ratepayer associations and allow them to collect information, whatever the municipality may choose. There's also going to be another regulation which will deal with if the municipality wants to charge a different amount in the user fee, or the manner of payment, or the manner of allocation, or the timing of the payment. And this can be, this different amount is applicable to different categories of records or different categories of persons requesting the record. So again, it may be up to the province to decide. Do commercial enterprises, for example, that really rely on information from municipalities, will they pay more for it by regulation? Will those, again, who are citizens simply looking to participate in the public process, pay less? What kinds of categories are going to be developed here? And then with respect to frivolous and vexation, again, it is going to be dealt with by regulation. So yet again, as we've been seeing really over the last 3 or 4 years, statutory definitions that perhaps a decade ago would have been left in the statute have been left to the regulation to be defined. So frivolous and vexation will be defined by the regulation to provide for standards as to what the municipality should decide as a frivolous and vexatious request. Restructuring. Restructuring had, as I said earlier, a lot of publicity, particularly after the first reading provisions of restructuring. And that had to do, from what I could see, a concern by municipalities that the province as big brother could step in and start restructuring municipalities completely against their wishes. And AMO in particular put up a spirited defense to the provisions that were in the first reading version of Bill 26. And the province listened to what AMO had to say, and those provisions have been considerably reduced, so that for the most part, it is the municipalities themselves, or perhaps any one municipality, that has to be in the position of initiating the restructuring. The other area that was of considerable difficulty, and I'll come back to the initiation, is personal liability for council members. There was a provision in the first reading which said that council members who contravene an interim restructuring regulation. So basically, if they contravene, and as I understood it, do something foolish before the municipality has been restructured that costs money, presumably for the new municipality, that they could potentially have been personally liable for that. And AMO, again, strongly defended that that was unduly restrictive. It suggested a degree of bad faith among the members of the councils that would be involved in the restructuring. And again, the government listened, and that provision was deleted. So when you look at the restructuring provisions, it's very interesting because they open with a broad purpose, which is different for other sections of the Planning Act. They say that restructuring has the broad purpose of being timely and efficient. They say that they want to facilitate restructurings over large geographical areas. And they say that they want to deal with restructurings that eliminate levels of government, transfer powers from one level of municipal government to another, or change municipal representation systems. So those are the broad areas that the government was attempting to deal with. Now, if we turn to specifically the issue of geographical boundary restructuring, there are basically two approaches that Bill 26 has put forward. One of them is that the municipality can make a proposal, and if the municipality makes a proposal and it complies with the regulations, so the regulations will establish a series of criteria, then if the municipality does it and it appears to be without significant public concern over the matter, then the minister shall implement that restructuring. The second way, and the one that I think will happen much more frequently, is that if a municipality requests, or if more than 75 residents in an unorganized territory request a restructuring review, then a commission shall be established. And the commission is going to operate again pursuant to regulation. And the regulations are going to deal with issues such as drafting the proposals, giving public notice for those proposals, public meetings to ensure that there are submissions made concerning those proposals. But it appears that once the commission goes through that process and makes a decision with respect to a restructuring, then either the minister or the commission have the ability to implement that decision once they've made it. So while the changes in deleting the earlier suggestion that the minister could simply implement restructuring appear to give the municipalities more control, it would appear that once the matter has been initiated at the commission level, the municipality who initiated may completely lose control of the process. And the suggestion that the municipality may have had to start off with as to an appropriate restructuring in their geographical area may be completely lost by the commission taking the matter on its own, listening to other submissions, and the commission simply coming up with its own decision as to what they think the restructuring should be. Now, for those of you in the Greater Toronto Area, the restructurings do not apply to areas that have regional government, metro government, district government, or the County of Oxford. All of those are exclusions to the definition of locality that's in the section. However, there may be kind of an interesting way for either a municipality on the fringe of any of those areas or the commission to address this issue, because it says that in the regulations, the commission can deal with any such greater areas as the minister may proscribe. So, for example, if I was thinking about if you take Orangeville as an example, and Orangeville decides that they want to commence a municipal restructuring process. If they go to the minister and say, you know, it makes an awful lot of sense to us that Caledon, even though it's in the region of Peel, should be participating in our restructuring process, if they convince the minister of the day that Caledon should be included, there would seem to be no reason that that's an area that the minister has prescribed that gets included in the commission at that point. So I think it's an interesting way that perhaps some of the fringe municipalities, particularly in some of the regions that you take, for example, York, where there are rural municipalities on the northern end, they may be open to the ability to be part of restructuring proposals for non-regional municipalities further out. Thirdly, licensing powers. I think it's quite clear for those who deal with licensing matters that the current provisions are absolutely archaic. The Municipal Act probably hasn't been changed for licensing for decades. There are 60 specific businesses that are set out in the Municipal Act that can be licensed, and the fees are very specifically set out. So, for example, a bakery license, as I understand it, and I don't recall having to deal with a bakery license, but as I understand it, it has to be $1. So it's quite clear that municipalities aren't even covering the costs of having to address some of these licensing requirements. So the province has proposed very broad and general powers for licensing. So rather than the list, what the province has done is they have basically established a series of exclusions. So not manufacturers, not wholesalers, not businesses in the natural resource area, not group homes, and not rental residential units. But otherwise, there are broad provisions with respect to licensing. Now here too, there were some changes that created some controversy between the first reading and the third reading. In the first reading, there was a provision that said that the licensing fees can reflect a revenue-raising intent and the fact that a privilege has been conferred on those that are getting the license. That has been changed to the phrase revenue raising and the phrase you got a privilege, you should pay for it have been deleted. And in return, what's been put in is the municipality must take into account the costs of administration and enforcement. Now, as we get into the Planning Act side of this, it occurred to me as I was thinking about that take into account sounds awfully close to have regard for. And I don't think that there's a suggestion that have regard for, and in my submission to you, take into account mean a limitation that they can only set the fees on the basis of the cost of administration and licensing, simply that they should take that into account. In fact, I think a municipality could quite well reverse their thinking and say, we need to take this into account to ensure that we are at least recouping the full costs of administration of licensing and enforcement of licenses in our municipality, and then we'll look at what additional amounts should be included in the license fees. I think what it will come down to is back to the political forum, that those that are making the decision are accountable every 3 years, and I expect that that continues for a number of these matters where great flexibility has been handed down to municipalities, that will be the ultimate limitation with respect to reasonable decision making is the ballot box. The other area that I think is quite interesting in licensing is that some very broad powers have been given with respect to a prohibition that the business can't operate without the license, terms, the ability to revoke licenses, the ability to put forward separate classes of licensed businesses, and conditions. Conditions that can be for a general class or the ability to do a special condition on a specific license holder. There's also the ability for broad inspection powers to ensure that these conditions are being dealt with, and specific powers to license equipment, places of business, and specific people who are part of the operations. Now, with respect to places of business, the one thing they did do was that they grandfathered the ability of a license holder where if they were in the same location prior to the passage of the Bill 26 provisions, that the municipality cannot put a location requirement that would prohibit the continued operation of that business at that location. So it's being grandfathered if it was in business up until the time that these provisions came into place. There must be a municipal bylaw. The bylaw provisions must address when licenses are going to be granted. So that's the balance to this broad list of here's all the things that you can do for municipal licensing. The balance to that is that you've got to fairly set it out in your bylaw. You've got to show when licenses are going to be granted and when they're not going to be granted, so that will give a degree of commercial certainty to those businesses in the municipality who are seeking a license, that they can look at the bylaw and try to determine on its face whether or not they meet those requirements. As well, the only other way that a municipality can choose not to grant the license is if there is a known concern about the honesty and integrity of the applicant for the license. That, I suspect, has got all sorts of ability for discussion, but that is specifically there. And then by regulation, the minister can say that they can limit the powers of the municipality to impose conditions, which I think is interesting. That's part of the bungee cord leaping back again, and that ability to limit the powers to control conditions has been specifically stated that it can be a regulation that is retroactive for 1 year. And what that, and it's clear on the basis of the legislation that what that means, for example, is if, let's say that the municipality has licensed new car dealers, if the minister passes a regulation that says, no, we don't want them licensed, we really want to promote the sales of new cars, and we're making it retroactive that you couldn't put forward that license as of a year ago, then there are provisions that require the municipality to repay license fees if they get addressed in the regulation. So they've covered off the fact that if they make it retroactive, the municipality can't keep the funding. So then fourthly, I just want to deal briefly with conservation authorities. And here there's just, I should make note of the fact that in your materials there is a paper which has much more detail than I'm trying to cover here. The paper is a summary. It's not meant to be some terrific, deep legal analysis with respect to the Act, because there's really nothing to base that on. What I've tried to do is simply open the door to the legislation, which otherwise looks quite impenetrable, and just give you an idea of where to go to look for things. But you're going to have to very specifically read through the provisions of Bill 26, and in particular the regulations that are passed under it. So I just noted that for under conservation authorities, I've put in the paper that they were under Schedule N, as in no, they should have been under Schedule M. They're at the very end of Schedule M under Part 3, and Schedule M is the main schedule. It has all of these Municipal Act changes in it. Again, with respect to streamlining, the province is stepping out of approving conservation authority projects where the province has no financial interest in the project. So if there's no grant that goes to a municipality, then the province says fine, or to the conservation authority, fine, you go off and you can deal with the matter as you wish. There is also no further provincial appointment of members to conservation authorities. And that becomes important when we start to consider the dissolution provisions that have been put in place. The dissolution provisions basically say member municipalities of a conservation authority, and it's a minimum of 2 of them, may request a meeting of the authority for purposes of discussing and potentially moving a motion to dissolve that particular conservation authority. A quorum is 2/3 of the appointed municipal members. So if there are any provincial members or provincially appointed members that are still on the commission at the time this matter comes forward, they specifically do not have a vote with respect to whether or not the commission is dissolved. With respect to this matter, there must be public notice of the intent to discuss potential dissolution of the conservation authority. There must be the opportunity for public submissions on that issue. And then once the matter comes forward to the commission on a quorum, so 2/3 quorum, 2/3 of the members present, so by my reckoning on a 9-member commission, 4 members out of 9 can determine that it will be dissolved, and the cabinet, the lieutenant governor and council, says may, so we're not necessarily bound to accept the wishes of that decision, but given that the power has been given to them, would appear likely that that is going to happen, may dissolve the conservation authority, provided that acceptable provisions have been made for flood control within that watershed, and there's been a proper plan for the disposition of the assets and liabilities of the conservation authority. As well, on a different note with respect to conservation authorities, I thought it was a very interesting regulation power which basically allows the minister to take back over the Conservation Authority powers, or in places where there is no conservation authority and the municipality is exercising those powers, to take back over the municipal powers for carrying out flood control, for operating the flood control provisions, and for, in fact, providing operating instructions for those flood control provisions. And there's a provision there that if the province takes it over, the municipality or the conservation authority shall reimburse the province for its costs, its operating costs, when they take back over those particular provisions. So again, you got to very carefully go through these provisions. Appears to be a great deal of user fees and streamlining that has been handed down, but there is an edge to it. There's an edge that if the province is unhappy with how matters are being addressed, there is also a much stronger ability than existed prior to Bill 26 to start to take those powers back. So there are a number of other areas that are dealt with in the paper. One specific area that I'm finding, and I've actually been dealing with several times since it's come out, is the whole area of user fees, toll roads, those sorts of things. That's going to be addressed by our next panel, and I leave it to them to deal with that. And as I say to you, I guess, in having my look of all of this is, in your various roles, either as a council at the municipality or in providing advice to the private sector, we're going to have to all, as a group, have a much harder look at the regulations. And it's going to be very difficult to make sure that we're up to date with respect to the contents of those regulations, because they, to a certain extent, are going to be much more important with respect to trying to give the four corners of the advice that we each need to give our clients than necessarily do the statutory provisions. Thank you. I'd like to call upon Bob Boxma, who has been introduced to you and has been working hard with Virginia to put together today's program, and Bob is going to introduce his panel.
Thanks, Jim. Good morning, everyone. We are going to have an overhead brought in, so while we're setting that up, I will introduce my two panel members. First is Nancy Bardecki. Nancy has been the Director of Municipal Finance Branch of the Ministry of Municipal Affairs and Housing since 1988. Prior to joining the ministry, she was Director of Farm Assistance Programs with the Ministry of Agriculture and Food, and has been a member of the Ontario Public Service since 1972. She's a member of the Ontario Municipal Employees Retirement System and holds a BA and MA in Economics and Public Finance from the University of Guelph. And Julia Ryan is a partner at Goodman, Phillips and Weinberg, where she concentrates on land development and municipal law matters. And of course, Julia has also been heavily involved in terms of Development Charges Act on behalf of UDI. Julia was called to the bar in 1974, having graduated from the University of Ottawa in 1972. And I'm going to ask Nancy and Julia to join me up here, and we'll go from there. Yeah, we're going to start with user fees, and I'm just going to very briefly outline the provisions of the Act dealing with it in Section 220.1, found at H14 of the appendices in the materials. Obviously, I'm not going to read it. You can read it as well as I can, but it just sub 2 says, despite any act, a municipality and a local board may pass bylaws imposing fees or charges on any class of persons for services or activities provided or done by or on behalf of it, for costs payable by it, for services or activities provided or done by or on behalf of any other municipality or local board, and C, for the use of its property, including property under its control. As I say, paraphrasing, if it moves, charge a fee, and if it doesn't move, charge double, I think is basically is going to be the name of the game as this develops. And then you'll see it continues on through 14 subsections. It indicates that it cannot be based upon income of a person. However, exemptions can be made for classes of persons who have an inability to pay, obviously seniors and that kind of thing. It makes it a tantamount to a direct tax, which can be added to the tax roll for collection. It allows phasing, staging, discounts if prepaid, penalties, and if not paid, etc. So it's very straightforward. It's there, and I think with that, I'm going to have Nancy deal with the policy rationale behind the section.
Okay, thank you, Bob. Can everybody hear me, or do I need to use the mic maybe?
Yeah, let me just put it over.
Okay. Thank you. There were actually 3 purposes in mind behind the user fee provisions in the Bill 26. The first was to allow municipalities to improve fairness. That is, where certain classes of citizens within a municipality and users of service use the service more heavily than other people in the community, we thought it was fairer to allow those people to pay specifically rather than everyone paying through the general mill rate. We also hoped that user fees would allow municipalities to influence demand in certain cases. For example, if user fees were used to finance garbage collection and waste disposal, hopefully the direct charges would encourage people to be more conservation-minded, produce less garbage, and so on. And then finally, the third purpose for the user fee provisions was to allow municipalities to raise revenue. Bob's already mentioned that the legislative provisions refer to in the nature of a direct tax. And specifically, to us at least, that means that municipalities are not confined to cost recovery in doing the user fees. Furthermore, they're not confined to having people who directly use the service pay. For example, we believe under the provisions of Bill 26, specifically these user fee provisions, that municipalities could charge people for shoveling the sidewalks in front of the street, even if the homeowner never left his home and didn't use the sidewalk in front of the street. We hope to be able to simplify the municipal legislation, all the municipal statutes, through Bill 26. We didn't have enough time to research things carefully at the time Bill 26 was introduced, but right now we have over 100 references in various municipal statutes allowing municipalities to collect one form of user fee or another. Some of these have significant restrictions on them, others are pretty straightforward and no restrictions at all. But I believe in your handouts there is at least a partial list of the main references to various user fee provisions within municipal statutes. Since we've got very powerful legislation through the Bill 26 provisions, Bob mentioned it says, despite any act, municipalities may introduce these user fees to finance services. We're really hoping that we can eliminate most or all of the other references in municipal legislation. But we'd be very interested in any feedback that you folks and other municipal people have on this issue. I'd just like to say a few words about the minister's regulation-making power. It was very controversial at the time that we introduced Bill 26. It is very powerful. It does allow the minister to impose restrictions on the manner in which municipalities charge user fees and the services that they charge the user fees to finance. And these restrictions can be either general, that is applied to all municipalities, or they can be specific and applied to a single municipality. It's not the minister's intention to use this power extensively. It's only there in the event that something extraordinary happens. We fully expect that municipalities are going to be using the user fee power in a very responsible way. But just in case somebody doesn't, or just in case we forgot something when drafting the legislation, the minister's regulation-making power is there. There are presently only 4 restrictions on municipalities. And again, these 4 restrictions are in your handout. I'll just go over them very, very quickly. First, you can't have the Crown as a sole class of person. That means, at least to us, that you can't charge the province of Ontario for sweeping the sidewalks in front of its building while you sweep everyone else's sidewalks for free and charge for it through the general mill rate. The second one we think is covered by the first one, but just to be on the safe side, we were specific about it, and that is you can't charge the province of Ontario for court security and for the transportation of prisoners. And finally, there's a regulation issued in February, along with the first 2, that said you can't charge for growth-related capital costs as outlined in Section 1 of the Development Charges Act. More recently, there was an additional provision added, that is after Bill 20 was passed, saying that you can't make charges under the Municipal Act for things that are allowed under the Planning Act, because the Planning Act imposes certain restrictions, and under Bill 26 it says despite any act there wouldn't have been any restrictions. So those are the only 4 restrictions there are right now. We're not planning any more unless an emergency or an appropriate situation arises. I'll move on quickly now to develop.
Yeah, just to say, those regs are found at B3 and B4 of your materials in Nancy's paper, so they're there.
And shall I just move on and say a few words about development charges right now? As everybody's probably aware, the province is undertaking a fundamental review of the Development Charges Act. And what Bill 20 did was say that unless you have authority from the Minister of Municipal Affairs and Housing, you can't increase a development charge or introduce a new development charge. Municipalities can lower their development charge without the approval of the minister, or they may extend the term of the existing development charge, even if that term does go beyond the 5 years that was the normal sunset date for development charges bylaw in the Development Charges Act. Now, the minister has stated that he would prefer to return the Development Charges Act to financing or focus on financing hard services. However, I want to emphasize that there's been no definition as to what constitutes a hard service. Different groups have different definitions as to what hard service should actually mean. We have had some consultation with stakeholders, primarily the municipal sector and the development industry. AMO actually didn't attend these consultations, but many individual municipalities did, and many organizations of municipal services, like library services, did as well. Over a 3-day period, we discussed the scope of development charges, that is, what charges you should be able to make or what services you should be able to make charges for, how you attribute those costs between new growth and existing ratepayers, how do you define appropriate service levels that you should be charging for, how can we make front-end financing provisions more user-friendly, that is, so that both municipalities and the development industry think they're more worthwhile using. We looked at the impact of development charges on rental and high-density housing, and if anything special should be done, if there was a negative impact there. And we also looked at financing alternatives for those services for which municipalities may no longer be able to charge development charges. Now, I'm sorry to report that between the development industry and the municipal sector, there really wasn't consensus on some fundamental issues. And I think now that my colleagues on the panel here are going to have a little bit of discussion on that, and you'll see what I mean.
Thanks, Nancy. Sure, and call on Julia first.
I'm going to talk about this in 3 aspects. First of all, I'm going to make a comment on the regulation that came in under Bill 26 and ask Nancy at the end to make a comment back on it. And that's the one that says there's no power under user fees to impose costs for growth-related net capital costs as defined in the Development Charges Act. I think the wording of that section does not convey what I understood to be the intent of that section. Concern, as I understand it, was expressed by the development community when user fees were introduced, and looking at the broad language in Bill 26, that the development industry might be classified as a class, and then development charges would be in effect imposed upon new development without any of the safeguards or protections that you find in the Development Charges Act. And I think that representations were made to the government that that ought not to be the case. And I believe I've seen some correspondence that came from the Deputy Minister that indicated that the intention of the government in bringing in this regulation was simply to ensure that municipalities did not say, oh, user fees, we'll use those provisions to impose our development charges, and let's forget all about the Development Charges Act. I don't think it was ever intended that you couldn't bring in user fees for a new community, for homeowners, for, to let them use their new swimming pool or the ice rink or things like that, and that those would be potentially growth-related capital costs if you decided to put a capital component in them. And I think there's a big difference between imposing user fees on real end users who are voters in a community and who can, through the power of the electorate, determine whether or not they actually ever wanted that arena or they ever wanted that community center in the first place, and decide whether or not they really wanted to pay for it. So I would appreciate it if, when we come to some rebuttal time here, which I know that I'll certainly want after Bob speaks, that maybe Nancy could address that. The second thing I'd like to just talk briefly about is the use of Bill 20 amendments. And John Maskern is here today from the town of Markham, and I thought I might just spend a minute on the process in which we're embroiled in the town of Markham with respect to the Bill 20 provisions. I did provide a paper that sort of outlines what Bill 20 did, and I'm sure you can all read that for yourselves. I don't intend to spend time on it. I think Nancy has hit all the highlights. But dealing with how it works in the real world, Markham has been working assiduously over the last many months to bring forward development charges that would allow the OPA 5 area in the town to develop. And OPA 5 is the new development area in the town. And in order for it to go forward, the hard service component of the development charges had never been enacted until the official plan amendment was approved, until secondary plans were going forward and development was actually ready to start. Markham has a system of a combination of town-wide and area-specific charges, and the town is divided up into areas for purposes of the hard services that are needed to serve those areas, and those bylaws now need to come forward for OPA 5. In addition, I think it, as a reason of being spooked somewhat by the dichotomy of the debate that's now going on between the hard and soft services, the town is also proposing an increase in its town-wide charge, and they've done that to a major extent, although not entirely, by shifting transit from soft services to hard. And this is part of the debate that's going on. What is really a hard service? And Markham is taking the position that transportation is really all one service, and therefore it's really hard. Transit's as hard as roads, and if you don't build as many roads, you're going to require more transit, and if you don't put the transit in, you'll have to build more roads, so it sort of goes round and round. So they have produced a study which proposes increases to the town-wide hard bylaw, but shifts transit as a soft cost into the town-wide hard, and they've also proposed these area-specific bylaws. Now, with Bill 20, you have to go to the minister to get these bylaws approved, And there's two groups of developers in the town of Markham, and unfortunately they're all my clients, so it's a pleasant dancing act. But you've got those developers who are really anxious to get going, and you've got those developers who are in no hurry to get going. The ones who want to get going, although they don't want to pay development charges, obviously, they want something in place because they need credit agreements and they may need front-ending agreements, and to ensure the highest degree of protection that they'll get their money back, they'd like to have the bylaws adopted. On the other hand, there are other people who say there's no need to have the bylaws adopted at all. And we've, in the meantime, are negotiating with the town of Markham as to what these new charges should contain. So the question became what to do. The developers made the proposal to the town that they don't need bylaws at all. They could simply collect the charges by taking LCs in the meantime, because once the bylaws are approved under Bill 20, they're approved retroactively to the later of the day that they're passed or the date stipulated in the bylaw. And I think in Markham's case that the date will be the date they're passed. So we argued that Markham had lots of protection because the bylaws would come into effect retroactively, and there are provisions in the Act that allow development charges to be collected as taxes, which in effect gives them a lien on the property and would allow them to sell it if the developers didn't pay it ultimately, even if they had obtained building permits in the meantime. The town wasn't too persuaded by that idea, and they're concerned about the possibility of what may happen down the line. There's some concern, in my view, I don't think this will come to fruition, but some concern on the municipal side that whatever the fundamental review is, that it will result in retroactive legislation going back, say, till June or whenever, say, Bill 20 came into effect. That would surprise me, given the number of fights I've had with the province trying to get them to do things retroactively, and they've always refused me. So I'm not sure that there's a great desire on the provincial side to enact anything retroactively. Anyway, what we ended up hammering out was a solution whereby the town enacted, so far, one bylaw for one developer restricted to his first phase of some 100+ units. And they took that bylaw and they took the two components that they're trying to have adopted. One is that pro rata share of their area-specific hard charge and the pro rata share of the increase in the town-wide charge. And we're going down to the ministry to see if that can be approved. And with some reluctance, the other developers are prepared, at least as of 10 o'clock this morning, to go along with this approach. We went down to meet with the ministry staff to talk about what would happen in terms of getting an approval. And it's going to be interesting to see how it's handled. They asked a lot of questions about why the town needed an increase in its town-wide component now. And that seems, or they don't commit themselves to anything, to indicate this thinking in the background that, well, maybe, you know, these really should be area-specific charges and should be hard charges. They asked a lot of questions about the transit component. And in addition, they asked if the developers supported it. And when we had the meeting, I couldn't really give them any assurances that the development community would support it. I'm hoping to be able to give those assurances. And we kind of walked away from the meeting, and I think John would agree with this, with some sense that there may be some reluctance to approve the component that might be said to be soft or town-wide. On the other hand, if the development community, if there's not a big objection from the development community, I think we stand a pretty good chance of getting it approved. Ministry staff don't give you any real indication of how the process will work, other than to say that the regional staff will do a report. It will go to Diana Jardine, from there to the assistant deputy, from there to the deputy, and from there to the minister, and that it will be reviewed and closely scrutinized at all levels, because this is the first one that's going through the mill. When you ask them how much time this will take, they don't know, although they do indicate that if there's a reason to speed it up, they will make every effort to speed it up, but they don't guarantee what the minister will do on a time frame. There are no time frames for anybody to put in an objection, so an objection could arrive on the minister's desk the day that he's about to sign it. And when you ask questions such as, will you be entitled to see their file, to see all the objections, etc., they don't say you won't. They say they're going to try and have an open process. but they don't really give you any commitments either. And they don't say, for example, if somebody objected out of the blue, that they would automatically notify Markham that that had occurred. And so I think that if somebody is thinking of going forward with a bylaw in this interim period, you're going to have to monitor it pretty closely to see what's going on. So as far as I know, Markham is the only bylaw that's proceeding at this time. And I know of other municipalities where they're starting their review process, but the ones that I'm aware of tend to be town-wide and a complete fundamental review of the last 5 years. And I don't know that those kinds of things are going to be looked upon favorably by the minister in the interim period. All the advice I've had from ministry staff is that the minister's really not interested in approving too many bylaws during this period, and that the test will be, I mean, are you ready to put a shovel in the ground? Which is the case with some of these developments in Markham. Turning to the fundamental review, the question is, where do we go from here? Nancy made allusion to the 3 days of stakeholder meetings that the province held. I guess it was about a month ago now. It was quite a marathon session, and there is floating around out there a summary of what people said at that meeting. I would say there was universal agreement on one thing, and that was that we need serious amendments to the Development Charges Act to make the front-ending provisions work. And I think on both sides of the table, there's recognition that that has to happen. But it's absolutely true that there's been no agreement at all on this soft, hard debate. And there have been a series of meetings between the Urban Development Institute and the Home Builders Association and the Association of Municipalities of Ontario. I would say that at this point those meetings are not going anywhere. I think in the initial stages there was some willingness, I don't want to put this at too high a level, but the development community sensed there was some willingness on the part of AMO representatives to negotiate about some of the more egregious examples of things that have been collected for under development charges. I think once they had a board meeting, and as the concern about the hard-soft debate became more apparent, they got their marching orders, which is to take the position that the status quo is the only thing that we can have, and I don't think there's any movement on their side at all. They do talk, in fairness, about trying to improve the transparency of the process and trying to make it clear that the reporting will have to be more transparent, more open, more service specific, and some of those amendments are already in Bill 20. And they also talk about requiring things like having something in the 10-year capital plan before it can go in the development charge, doing feasibility studies to make sure you can afford to operate them. I think from the developer side of the table, those things are all well and good, but at the end of the day, more process doesn't really do it. Because we have found, I think, in the last 5 years that really getting behind the numbers and doing a reality check, it's really costly, it's very time consuming. I don't think the municipalities like it. I don't think the developers like it. And I've found in my personal experience that, well, municipalities are quite used to being challenged with zoning bylaws and official plans and things like that, and they don't really like it, and they sometimes give you a hard time about it. Challenging them on these fiscal issues just sends them into orbit. I mean, you get people who won't talk to you. There's something visceral there in some municipalities about the notion that the development community would have the temerity to challenge these grandiose expenditure plans that we've seen. So it hasn't all been sweetness and light through these negotiations over the past few years. And I guess that I would have to say that I really believe that the provincial message of fiscal responsibility has not really percolated down to the municipal level yet. I know there's a lot of talk about cutbacks, and we're going to be threatened by cutbacks in grants and all those kinds of things. And I think those are legitimate and real fears that municipalities have. But when it comes to their service levels, I don't really see realism quite yet setting in. And I think that what we're seeing is a level of serious concern about tax increases. And what you see is the automatic assumption that if soft services are off the table, or if the status quo is not maintained on development charges, taxes are going to automatically skyrocket. And there are many examples of that around. I mean, many municipalities have had reports to that effect from their staff. There's a regional treasurer's report out there that was I think, written by the treasurer of the region of Peel that's floating around for use among the regional chairmen. And, you know, it just says, no development charges, no soft services, the taxes are going to go off the wall. Markham, not to pick on Markham, but John is here today, announced last, I think it was Wednesday or Thursday, that there's going to be a development freeze in Markham effective today. And that matter is going to planning committee or council today for debate, I'm told. And in the course of that discussion with the development community, Mayor Cousins said that Markham will not entertain lower service standards. So certainly things have heightened, and I think every municipality that I'm aware of has passed a resolution condemning the fundamental review of the Development Charges Act and saying that soft services are simply not up for debate. My personal view, and I want to stress this is personal, it doesn't represent anybody or any developer or municipality, is I don't think the debate is really about hard services versus soft services. I think there are two issues. One is, what are the essential services that we need to provide to communities? And secondly, what are the service standards at which they should be provided? In other words, what can we afford? Some things, in my view, should clearly be off the table for development charges. And if people want them and want to raise money in the community for them and believe that they're an essential part of their community, by all means. And many of these things are laudable and worthwhile items, but they are the kinds of things that are really easy just to throw into a charge, and they include museums, art galleries, the notion that the city hall is going to expand by X square feet for every new person that comes in. I mean, we've all seen in the last 10 years, every municipality in the GTA practically has built itself this wonderful edifice to its own self at huge cost, either to the development community or the taxpayers. And now you're sort of walking around saying, like why? Maybe part of some of these municipalities should just be eliminated. Other big things, huge waterfront parks. I mean, if you take Halton and Mississauga and places like this, there's, you know, nobody thought of spending all this money on waterfront parks until the Development Charges Act came in. Then all of a sudden, well, let's go for it. The Living Arts Centers, Mississauga, huge cost in there for its new Living Arts Center. Mississauga, in its bylaw, had a cost in for a garden, which was going to be the second Butchert Gardens in Canada. And the way they determined whether they needed that was they handed out survey forms at garden club meetings. And they asked people, what kind of a garden would you like? One that cost, and I don't remember these exact figures, one that cost 10 million, one that cost 20 million, or one that cost 32 million. Well, guess which one the garden clubs picked, right? $32 million. There we were with the development charge passed in 1991, $32 million in it. Mostly, and I don't remember whether it was an allocation to growth or not growth, but for a garden. And a garden might be wonderful in Mississauga, but it's not altogether clear to me that every new homeowner, particularly the young home buyer, really wants to pay thousands of dollars for that. And I've included in my material, you can have a look at it, some charts that have recently been put out by the Urban Development Institute about government fees and charges as a percentage of the cost of townhouses. And it's really interesting as you look across the GTA, where prices of townhouses tend to change depending on what region you're in. Total government costs and charges are in the vicinity of a quarter of the total cost of the home. That's an awful lot to load on to the first-time home buyer in particular, but anybody who's buying a new home, who's trying to get the capital together for the down payment, to be paying 25% of it in government charges and taxes is a huge amount of money. To me, the question is, we got to find some new ways of doing business. We have to look at all ways of financing these things. And you just can't automatically shift the cost to the development charge because you've got somebody there. Nobody cares whether developers scream or not. I mean, you know, they're a universal whipping boy for all the evils of growth in the last few years. And I mean, there's some justification to complaints about developers. I'm not suggesting there isn't. But it is a very easy thing for a politician to just say, nobody cares whether the developers whine, and the guy who's going to pay this money, he's not there to vote for me anyway, so let's just keep on marching. And I am aware of clients of mine who have had staff members at municipalities come up to them and say, please come and help me with my council. Tell them we can't afford all this stuff. Tell them we've got to get more fiscally responsible. I can't do it. I need you to help me. But I'm, if I speak up too loudly, I'm going to be in trouble. So, it is, I think, a fundamental issue. I think there are other things that could possibly be off the table. At the very least, a lot of these soft services have to be shared automatically between growth and non-growth, because I can't think of any other way to bring fiscal discipline to the problem. If you knew that politicians could resist the easy thing of shifting costs onto growth, maybe this wouldn't be necessary. But I just personally can't think of any other way to do it. I see the development charges are wish lists, many of these things. It's the easy thing to do. Throw it in, maybe you'll build it, maybe you won't, but let's put it in there, let's be safe. And so everybody succumbs to the temptation. Those things to me that either could be off the table or at the very least shared include probably all the softs, but in particular furniture and equipment, parkland above the Planning Act. I mean, if you look at the standards we have for parkland, drive through the city of Toronto, look at the school sites, look how big they are, and look at how they serve for the local park. You go to the suburbs, and they think they're doing you a big favor if they ask you for 6 acres for a park and 6 acres for a school. And they tell you they've compromised their standards because they brought it down from 8.5 for each. And look, we just can't afford that. Drive through and ask yourself, those large boulevards, I never can figure out, no one can ever tell me why I can drive up Avenue Road or Mount Pleasant at night, and I don't see those big boulevards, and the traffic seems to move along, and it doesn't seem to be a huge problem, and I drive every place in the GTA, in the new areas, and there are huge boulevards, huge sidewalks that nobody ever walks on, and huge boulevards on the other side of the sidewalk before you get to the guy's backyard, and then you see a fence that hasn't been painted in 5 years because it's the outside and it's falling down. But do we really need all that stuff? I mean, did anybody ever ask themselves those questions? And it's just easy not to do it. So in summary, I think the reality is today we have to make choices, and whether we like it or not. And a lot of us won't like it because as taxpayers, we'd like to have more and more as long as we didn't have to pay for it, as long as somebody else paid for it. We're all like that. And it's difficult for the politicians to resist that. They are in a difficult position, but they are going to have to resist it. And on the development charges side, I don't see any way to do it except cut at the soft service level for the ability to impose the charges.
Thanks, Joanne. I'm going to surprisingly not, in fact, disagree all that much with Julia in terms of, first of all, I have not been, although I was very involved on behalf of the town of Oakville vis-a-vis the approval of their development charge bylaw under existing legislation. I have not been involved in terms of the stakeholder process, so I'm not going to be able to offer. I certainly don't represent the municipalities and their input. However, I have certainly continued to work hand in hand with the treasurer and deputy treasurer of Oakville, and again, and as Julie mentioned, they have made a submission to the minister in terms of revisions. I guess the great concern, and it's reflected in the submission made by Oakville, and it was mentioned by Nancy in her opening statements, is the fact that the minister in November announced that the codes would be reviewing the Development Charges Act with a review to returning to the original purpose of development charges to pay for hard services. And the great concern, first of all, I disagree that was ever the intention of development charges to begin with. Certainly in the growth municipalities, combination of lot levies and agreements under the Planning Act, for 20 years, services have been provided, both hard and soft, by the development industry. So there's nothing new in development charges, although not a consolidation of lot levies or putting it into statute form. If you combine what was available and extracted through, as I say, Planning Act agreements, subdivision agreements, etc., and lot levies, it's been a system that's existed for, as I say, certainly 20 years. I mean, there were lot levy cases going back to the late 70s, so it's not a new concept in that regard. But it is this concern of the lack of definition of hard services, because if the minister meant by hard services sewer, water, stormwater, and roads, then there is a major concern. A little quote: "You need to be able to drive up to the house, walk in, turn on the tap, and flush the toilet. But you also need a neighborhood park for your children, a fire station within 5 or 6 minute response time, water disposal capacity, trucks to clear the snow away, an electrical substation to provide power, community facilities for teenagers and older residents, a detachment to accommodate those policing the area," and so on. I mean, that's what a livable, workable community is, and that's what development charges was intended to, the scope to cover those kinds of services. I thought this might be more heated than that, but it's not going to take that tone, because hearing Julia talk about that it is a question of what determining the essential services and then the standard to which they're provided, I personally don't disagree with that. I'm just going to quote for some promotional material, however, on behalf of that's cited in I think these basically come from the Globe and Mail Home section in Saturday's Globe. In Burlington, close to all amenities and transportation, including schools, parks, shopping, and golf courses. Oakville, what a picturesque setting. Glen Abbey Golf Course, stunning wooded ravines along 16 Mile Creek, and numerous walking trails at your doorstep. Innisfil, enjoy swimming, tennis, baseball, and exclusive boat launching facilities in your own backyard, just steps from Innisfil Beach Waterfront Park. Aurora, bordered by exceptionally maintained parks, naturalized woodlots, and the meandering East Holland River, this parkside community offers families a safe and friendly neighborhood, all within a short stroll of baseball diamonds, nature trails, and the Aurora Leisure Complex. I mean, this is part and parcel of the marketing, and understandably of home builders, of new home development. And the difficulty with a municipality is that it basically has 3 sources of revenue. It has, in this case, development charges, it has existing taxpayers, and it has provincial grants and subsidies, but which we know in terms of the last, those are reducing considerably, and there just aren't other sources or other available revenues that municipalities can look to cover the costs. Now, Oakville again, and Julia hits on, if you take hard services to be restricted to the hard services of, as I say, road, sewers, and et cetera, then they estimated, with the elimination of the soft service component, an increase in property taxes of 8.3% in the first year. Now, politically, you can appreciate that just in today's mindset, that's political suicide. Obviously, if that was attempted to be imposed upon the existing tax base, it just wouldn't fly. And I don't think that's an unrealistic, as I say, because it's a question of if the act restricts to hard services, then that would be the outfall from it. I think, again, I can only cite Oakville as an example, but which I think is hopeful, and a hopeful sign in terms of the reality of today. They, in terms of their capital program and projected priorities in 1995, they projected a total gross cost of the town's growth-related capital program for a 10-year period has been reduced from $252 million to $125 in 95 to $125 million in 1996. And both programs have assumed capital charge financing at a rate of approximately 60% to finance the growth-related share of the capital works. And the amount of development charge financing assumed to be required over the 10-year period will likely be reduced from $144 million to $80 million. So again, I think even within the existing parameters of the existing legislation, I think reality has required the growth municipalities, and again, those are the ones within the GTA, to sit down and say, all right, what is essential? What can we afford? Because there is still the component of most charges that has both the existing existing taxpayer, existing resident component, which has to be financed through the tax base, and then the new growth component, which is then has been raised from development charges. And as I say, I think there's even that what has existed is a reality in today's economy, that it is just going to require a pulling back, a cutting back on the level, both the services to be provided and the levels of services at which they are provided. I don't know that I have Nancy, did you have anything you wanted to add in terms of, because you have been in on the stakeholders meetings, and in terms of the other concerns expressed by municipalities in a general?
I think you've reasonably covered the concerns of municipalities. Just one other issue that they have expressed concern about, and that is transition. Would you like to
No, go ahead.
go further?
Yeah.
Okay, municipalities are concerned that they have constructed capital facilities already, anticipating that they would be able to charge development charges over the next 5 to 10 years in order to refund the debentures that they issued to build those facilities and finance those facilities. And they are one of the big issues that came up in our discussions on the fundamental review last month was, how are we going to cope with refunding those debentures when we've already spent the money, produced the facilities in anticipation of development and in anticipation of the development charges that development would bring. And they're very concerned about what they're going to do if development charges can no longer be charged for those services that they had already anticipated and provided.
Exactly. And for those of which they've started partial collection for, et cetera, and with the intention of beginning the facilities. Another concern too is that if the soft services, the hockey rinks, the baseball diamonds, et cetera, are not going to be able to be funded through development charges, a real concern upon the effect that will have upon communities within a municipality, as to existing communities who have those facilities now, and therefore the ability to use, let's say, the pool. If you can get your kid in for enroll in a program for once a week, that's fine. But if you have a whole new community that then doesn't have its swimming pool and then is using yours, so then you can only get your kid in once every 2 weeks, or there's a fight to get your kid in at all. I mean, there's that real concern and a belief that the existing taxpayers who are there, who have paid for their facilities, are going to be very resistant to new communities coming in and taking over those facilities, a concern of leading to gated communities, if you will, or requiring a passport for use of, to show that you're, in Oakville's case, that you're a Glen Abbey resident and therefore can use the Glen Abbey facilities. But if you're from West Oak Trails, sorry, and you haven't got those facilities, go to Burlington or whatever. So anyway, that is a real concern as well.
I understand the concern, but I think it's a little overstated. An example is in I think it's in Richmond Hill. I think it's their baseball diamonds. You could reserve them, and there was no fee. And they just had waiting lists for baseball diamonds, and there was this perceived huge shortage of baseball diamonds. So they instituted something like a $25 fee to reserve. Well, now, there's huge surplus capacity. So, some of this is in our mind. Some of it may prove out to be real, but some of it, I think, is what people just have this, Chicken Little syndrome, the sky is going to fall in. The notion that everybody has to have available to them at all times, at every instant, every facility they might ever dream, that they think, well, maybe we might go down there 3 Sundays from now and play baseball. We have to get away from that, and that's one of the things that I think user fees may do. And while I have some concern about user fees from 2 perspectives, one is there are always the people who can't afford, and I think that is a serious and legitimate issue. And secondly, I do have some overall societal concern with the notion that you're sort of splitting everybody up into little groups, and it's my little group and I can afford to do this or I can afford to do that, and nobody else comes in. And I think that is part of this growth non-growth dichotomy, and part of the fragmentation that one sometimes senses has happened in society today. And I think that I have some legitimate concerns about that. But I think on the other side of the ledger, which right now I think we have to address, is the fiscal responsibility side. And if you don't make people cognizant of the cost of things, we all want things we don't have to pay for. I mean, that's a human reaction. It's not, there's no difference between an existing or a new ratepayer or anybody else in that. As long as we don't have to pay for it, it's a great idea. And there are a lot of great ideas out there, but you know, when it comes right down to it, at the end of the day, somebody has to pay. And we can only have what we can afford to pay for.
And on that cheery note, I'm going to thank Nancy and Julia, and we'll move on. Thanks. Our next speaker is Ian Rowe. Ian is a partner in the law firm of Berger Rowe, and his practice focuses exclusively on municipal and administrative law, consisting of representing a variety of parties, both public and private. Ian obtained his BA in philosophy from the University of Toronto, his LLB from Osgoode Hall, and was called to the bar in 1978. He has been the author of a number of publications, including Law Society of Upper Canada, the Ontario Municipal Board for the Non-Specialist, Consent and Minor Variance Appeals, Canadian Institute, Borough Planning, Farm-Related Services, and Ian is going to deal with licensing. Ian.
Thank you, Bob. First of all, Jim has already dealt with a number of issues that I was intending to address, and so if my talk is even more disjointed than I normally am, that'll be my excuse. As he has indicated, there's really a new regime for licensing, and I just want to touch on the pre-Bill 26 regime as a bit of a review. Section 109 of the old Act talked about licensing trade, calling, businesses, or occupations, and prohibiting the carrying on of such activity without a license, and you could regulate hours of operation, fixed licensing fees, and there was a recognition that the licensing fee could be in the nature of a tax. That act really specifically licensed specific businesses and specific activities. What we have done with respect to the new act is a much more generalized view of the licensing power. There were attempts at reform with the introduction of Section 109.1 of the old Municipal Act, and it introduced powers with respect to the municipality's ability to regulate more closely in terms of refusing licenses, looking at the conduct of the licensee, and there were appeals to the Divisional Court for suspensions. And that procedure, those powers have really been enlarged and generalized with respect to Bill 26. As I indicated, a more generalized approach has been introduced, and really all businesses within the municipal corporate limits can now be licensed with a number of exceptions. Business is defined in Section 257.1, and it is a very broad definition. It can include retail sales. It can include law offices in my submission, although we hope that all the municipal solicitors will recommend against that to their clients. And the exceptions are really based on industrial or natural resources activities, such as manufacturing, sale by wholesale, or extractive processes for natural resources. Now, there are specific licensing provisions that were maintained in the Municipal Act, and there is a list of them, and they generally fall into categories whether it's body rub parlors, adult entertainment parlors, billiards, cabs, waxworks, tourists and trailer camps, and transient traders. And those often fall into morality issues or difficult issues with respect to activities that can lead to nuisances or other difficulties, or areas where protection of the public was particularly required. And those particular sections had very specific provisions relating to those kind of activities that didn't relate to licensing issues generally. So they have been maintained because of those specific provisions. Now, who can license? There was a division of labor in the field of licensing between the Police Services Board and the Council of the Municipality, and that division has now disappeared. The power is now reposed in local municipalities. That's defined as city, town, village, or township. And the rights of the Police Services Board to license matters such as taxi cabs, etc., billiard pool tables, music halls, bowling alleys, and the like, are now to be exercised by the local municipality. There are transition provisions with respect to those kinds of licensing bylaws, and there is a 5-year window for those transition periods from the date of passage of the bylaw. Now, having taken away that power from the Police Services Board, the municipality can delegate it back, but it is not automatic, and therefore a municipality that wishes to rely on the Police Services Board to license those kinds of activities, and if they are to contemplate any amendments to their existing bylaws, must pass a bylaw delegating the specific authority to the Police Services Board. As Jim has mentioned, the fees with respect to licensing is a very big issue. Now, in the previous act, fees as a form of taxation has been recognized. And as has been mentioned, the concept of user fees and downloading and less grant money available has opened up the necessity for municipalities to look for other areas of generating income. And licensing was certainly an area that's of great interest to municipalities in that regard. The old act did have some very specific licensing ceilings, and they were, in some cases, ludicrously low. And therefore, a municipality undertaking licensing of that kind of activity was clearly undertaking a public service for which it was not recovering its costs from the area being licensed. Now, the phrase, taking into account the cost of administering and enforcing bylaws of the municipality licensing businesses, is open to a number of different interpretations. I'm sure that the municipality will argue that it is to cover the situation which previously existed where they were losing money on certain classes of licenses. The licensees, no doubt, will indicate that it should be more of a revenue-neutral activity, regulating for the public good, and that the cost of licenses should relate directly to the cost of administrating and regulating the people licensed. I suspect that there'll be some case law to determine what that phrase will be, but since I normally act for municipalities, I would certainly argue that the recognition of taxes that had previously been in the Act couldn't possibly have been intended to be removed, and therefore the power of the municipality to generate revenue is preserved and perhaps enhanced. Jim has mentioned the ministry's, what we've called in our office, a yo-yo clause with respect to the ability to regulate retroactively with respect to license fees, and that would strengthen my argument that it was intended to allow revenue production, and that the ministry's concern is if the grab for money is just too unconscionable, that he could step in and take measures against that. Now, the discretion with respect to licensing and the process is set out in the Act and at page 5 of the paper, and there's a series that I won't go through of powers and the procedures that are involved now, which are crystallized within the Act. And as a result of that procedure, Section 109.1 of the Municipal Act has been repealed. And in my respectful submission that the Council really has now got broader areas with regard to considering licensing issues. And the integrity and honesty and conduct is certainly introduced in Section 257.3 and 109.1, and the provisions with respect to that issue have been replaced. There has been a mention of the sunset provisions, and the bylaws, licensing bylaws in the past could go on forever until the municipality had reviewed them and amended them. Now all bylaws will expire the earlier of 5 years after the amendments come into force, and that was January 30th, 1996, or 5 years from the day of passage. So all bylaws will automatically expire on January 30th, 2001, if they have not been amended and extended. Now, speaking of the minister's overriding power, as I have mentioned, there is retroactivity, so the municipality, in determining what the fees will be, has to worry about having to pay them back. I am told that this is a power which will be exercised very cautiously, and to date there have been no regulations dealing with this issue. The only regulations I'm aware of with respect to the provision of licensing was already been referred to, that the minister has prohibited licensing of group homes or rental units, but there has been no attempt to turn back any revenue-producing licensing fees, and we'll be waiting to see when the first time that happened. I understand that there was a licensing fee, I believe it was in Windsor, that got the minister excited, but to date he's done nothing about that. Really, I think Jim has covered off everything else that I wanted to say about licensing, and therefore I won't belabor the point, and perhaps we can just have an earlier coffee break than you were anticipating. Thank you very much.
Thanks, Ian. Then I think if we can, then we should plan to, let me see how maybe we can join back at 11 o'clock and we'll start 11. That'll give us 10 or 11 minutes for coffee, and then we'll reconvene at 11. Thanks.